Hello, my name is Chi Din. I'm with Avignon Realty Coaching and Training. Today, I will go over the promulgated by the Texas Real Estate Commission TREC residential condominium contract resale. And this is the updated version. And you can see here, there's red line that's been crossed through to show where the changes are. Now, I actually went into the Texas Real Estate Commissioner website and downloaded this form. This residential condominium contract resale, the notice here is not for use where seller owns fee simple title to land beneath the unit. Then paragraph number 1, parties. The party to this contract are the seller and buyer. So their names will go in these lines. Seller agrees to sell and convey to buyer, and buyer agrees to buy from the seller the property defined below. And here is paragraph 2, property and condominiums documents. So number 1, this is the information regarding the condominium unit. Okay, and you can see in here, there's unit number and building. Where's with the building information will go here, address and city, county. And then number 2, improvements. These are, all fixtures and improvements attached to the above described real property, including without limitation the following permanently installed and built-in items. So the items are listed here. So this is the change. It's the red cross out. That's the change for improvements for this contract. Number 3, accessories. The blue is the new update or added into this regarding the accessories. You can see security system that are not fixtures. Then there's also controls, include sellers transferable rights to the software and application used to access and control improvements for accessories, and hardware used solely to control improvements and accessories. So accessory is any item including window, air conditioning unit, stove, fireplace, screens, curtains and rods. Those are accessories. Then you have exclusions. The following improvements and accessories will be retained by seller and must be removed prior to delivery of possession. So if the seller have anything that they want to retain, and it must be removed before the delivery, before the exchange or delivery property to the buyer. Then we have B, the declaration. Bylaws and any rules of the association are called documents. When they are referring to documents, that is, again, the declaration, bylaws, and any rules of the association. And just check one box only. 1, if the buyer has received a copy of the documents, buyer is advised to read the documents before signing the contract. If the buyer has received a copy of the document, then 1 will be checked. And then if buyer has not received a copy of the documents and seller expense, so deliver the documents to buyer within this amount of days after the effective date of the contract, then this will be checked instead. And then C is this resale certificate from the Condominium Owners Association is called the certificate. And the certificate must be in a form promulgated by TREC or required by the parties. And the certificate must have been prepared at seller's expense no more than 3 months before the date it is delivered to buyer, and must contain a minimum the information required by section 82.157 Texas Property Code. Okay, so that's C for resale certificate. Then we have also continue regarding resale certificate, check one box only. If the buyer has received the certificate, check number 1. If buyer has not received the certificate and seller shall deliver the certificate to buyer within X amount of days after the effective date of the contract, then number 2 will be checked. Or number 3, buyer has received seller's affidavit that seller requested information from the association concerning this financial condition as required by the Texas Property Code, and that the association did not provide a certificate or information required in the certificate, and that buyer and seller agreed to waive the requirement to furnish the certificate. So if that's the case, then 3 would be checked off. Then we have D. If the documents reveal that the property is subject to a right of refusal under which the association or a member of the association may purchase the property, the effective date shall be amended to the date that the buyer receives a copy of the association's certification that seller has complied with the requirements under the right of refusal, and all person who may exercise the right of refusal have not exercised and have waived the right to buy the property. So if buyer does not receive the association certification within X amount of days after the effective date, or if the right of refusal is exercised, this contract shall be terminated and the earnest money shall be refunded to buyer. So that is D. And wherever there requirement of initial for identification by buyer and seller, the initial will go here. And then on the top of this area, on top of the page, contract concerning the property address will need to go here. And you see this change. This is actually a 30-14 instead of 30-13. And this is 11, that's November the 10th, 2020, instead of February 12th, 2018. So the date is updated according to the changes. Now we have sales price, and this is A is the cash portion of sales price payable to buyer at closing. B is a sum of all financing described in the attached. That's third-party financing addendum, or loan assumption addendum, or seller financing. So one of these needs to be checked. And the sales price is the sum of this line A and B. That's the sum here, and that's the sales price. So that's 3 sales price. 4, you have leases. And this section originally was the license holder disclosure. So that's completely removed. And now we have leases in this paragraph 4 instead. So leases, except as disclosed in this contract, seller is not aware of any leases affecting the property. After the effective date, seller may not, without buyer's written consent, create a new lease, amend any existing lease, or convey any interest in the property. Check all applicable boxes. So A, residential leases. The property is subject to one or more residential leases, and the addendum regarding residential leases is attached to this contract. This is the new addendum regarding residential leases. If you check this right here, residential leases, you will need to fill this out. Addendum regarding residential leases. This is the new addendum. And then if you check fixture leases, fixtures on the property are subject to one or more fixture leases. For example, solar panels, propane tanks, water softener, security system, and the addendum regarding fixture leases is attached to this contract. So if you check B, then the addendum regarding fixture leases will need to be filled out. That's paragraph 4. Now paragraph 5, earnest money and termination option. And this is what has been removed, termination of option. So A, deliver earnest money and option fee. So again, within 3 days after the effective date, buyer must deliver to escrow agent at this address the amount of earnest money and also this amount as option fee. And the earnest money and option fee shall be made payable to escrow agent and may be paid separately or combined in a single payment. So you want to work with the title company. I mean, they may have a way where you can wire the money to them instead of bringing a check, and the payment can be in one lump sum payment or 2 separate payments. And now that is the change, is it needs to be made payable to the escrow agent. Buyer shall deliver additional earnest money, this amount to escrow agent within X amount of days after the effective date of this contract. So if the last day to deliver the earnest money, option money, and the additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money, option fee, or the additional earnest money as applicable is extended into the end of the next day that is not a Saturday, Sunday, or legal holiday. 3, the amount escrow agent receives under this paragraph shall be applied first to the option fee, then to the earnest money, and then to the additional earnest money. Again, the amount received is prioritized. Go first to the option fee, then the earnest money, and then the additional earnest money. 4, buyer authorizes escrow agent to release and deliver the option fee to seller at any time without further notice to or consent from the buyer, or releases escrow agent from liability for delivery of the option fee to seller. The option fee would be credited to the sales price at closing. So that's also before the other contract under option fee, there's an option what to do with the option fee, but here just going to go credit to the sales price at closing. Paragraph B, termination option. For nominal consideration, the receipt of which seller acknowledges and buyer's agreement to pay the option fee within the time required, seller grants buyer the unrestricted right to terminate this contract by giving notice of termination to seller within X amount of days after the effective date of this contract as option period. Notices under this paragraphs must be given by 5 p.m. local time where the property is located by the date specified. So if buyer gives notice of termination within the time prescribed, the option fee will not be refunded, and escrow agent shall release any option fee remaining with escrow agent to seller, and any earnest money will be refunded to buyer. The option fee will not be refunded, and the earnest money will be refunded to the buyer. Failure to timely deliver earnest money. If buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both by providing notice to buyer before buyers delivers the earnest money. And then D, failure to timely deliver option money. So if no dollar amount is stated on the option fee, or if buyer fails to deliver the option fee within the time required, buyer shall not have the unrestricted right to terminate this contract under paragraph 5. E, time is the essence for this paragraph in strict compliance with the time for performance required. Then there is paragraph 6, title policy. Either seller shall furnish to buyer at seller's expense or buyer expense at an owner's policy of title insurance issued by the name of the title company will go here. So this is going to be negotiated. Who's going to pay for the title policy? Exclusions and exceptions. These are the exceptions here. B, commitment. Within 20 days after the title company receives a copy of this contract, seller shall furnish to buyer a commitment for title insurance. Okay, so this goes more into commitment. C, objections. The buyer may object in writing to defects, exceptions, or encumbrances to title. And then there's also buyer must object the earlier the closing day, this days after buyer receives the commitment and exception documents. Then we have D, title notices. And inside of title notices, there's abstract or title policy. There's statutory tax districts and tie waters and annexation. Of any of these area that apply to the property, you will get those title notices. Property located in the certificated service area of utility service provider. Again, that's another notice if that apply to your property. And then if there's any transfer fees, if the property is in an area where needs propane gas system service, there's actually an addendum for that for notice, and notice of water level fluctuations if your property is located in that area, then the notice will all be under, again, title notices. Then there's property conditions, access, inspections, and utilities. So seller shall permit the buyer and the buyer's agent to access the property at reasonable times to go in, and buyer may have the property inspected by an inspector, selected by buyer, and licensed by TREC, or otherwise permitted by law to make inspections. Any kind of hydrostatic testing must be separately authorized by seller in writing, and seller at seller's expense shall immediately cause existing utilities to be turned on and shall keep the utilities during the time this contract is in effect. And then there's seller's disclosure notice pursuant to 5.008 Texas Property Code. And you just check one. If the buyer has received the notice, then one is checked. And then if buyer has not received the notice, then there's within certain amount of days after the effective date of this contract, seller shall deliver the notice to buyer. Or number 3, this Texas Property Code does not require the seller to furnish the notice. So one of these needs to be checked. And then there's also seller disclosure of lead-based paying, and lead-based paying hazard is required by federal law for a residential dwelling that's constructed prior to 1978. And there's actually a addendum for the seller disclosure of lead-based paying and lead-based paying hazards. And then D, acceptance of property's condition as is. So it means that the present condition of the property with any or all defects and without warranty except for the warranties of title and the warranty in this contract. And then we have down here, you can check 1, buyer accept the property as is, or 2, buyer accept the property as is, provided seller expense to complete the following specific repairs and treatments. You definitely want to check one of these, and then you can do the inspection during the option period. And then E, lender require repairs and treatments. Unless otherwise agree in writing, neither party is obligated to pay for lender required repairs. And then completions of repairs and treatments. More, unless otherwise agree in writing, seller shall complete all agreed repairs and treatments prior to the closing date. And then there's environmental matters. There's actually an addenda for this. If there's presence of wetlands or toxic substance on the property, then there's an addendum that needs to go with this contract. And then we have your H, residential service contract. And this is negotiated with the seller. A buyer may purchase a residential service contract from a residential service company licensed by TREC. And if buyer purchase a residential service contract, seller shall reimburse the buyer at closing for the cost of residential service contract, an amount not to exceed this amount. And then it's negotiable, not necessarily every situation the seller will pay for the residential service contracts. And then in bold black here, the purchase of a residential service contract is optional. Similar coverage may be purchased from various companies authorized to do business in Texas. Then there you have your brokers and sales agents. A broker or sales agent disclosure. Texas law requires a real estate broker or sales agent who is a party to a transaction or acting on behalf of a spouse, parent, child, business entity in which the broker or sales agent owns more than 10%, or a trust for which the broker or sales agent acts as a trustee, or of which the broker or sales agent or the broker or sales agent spouse, parent, or child is a beneficiary, to notify the other party in writing before entering into a contract of sales. This close if this applied to you. And then there's broker fees here. All obligations of the parties of the payments of broker's fees are contained in separate written agreements. So this is still here, but then this section, this part A is also added. Closing, paragraph 9. In the closing of sales would be on and before. Need to negotiate a date there between seller and buyer. This is what will happen at the closing. Possession, A, buyer's possession. This is what it's going to look like for buyers to have possession of their property. Seller shall deliver the buyer to buyer possession of the property in its present required condition, ordinary wear and tear, except, of course, upon closing and funding, or according to a temporary residential lease form promulgated by TREC or other written lease required by the parties. So just check one that actually apply here. And then in bold black, consult your insurance agent prior to change of ownership and possession, because insurance coverage may be limited or terminated. Then the absence of a written lease or appropriate insurance coverage may expose the parties to economic loss. And then B, to smart devices. Smart devices being a device that connects to the internet to enable remote use, monitoring, and management of the property. Items identified in any non-realty items addendum or items in a fixture lease assigned to buyer. And at the time seller delivers possession of the property to buyer, seller shall, 1, deliver to buyer written information containing all access codes, usernames, passwords, and applications buyer will need to access, operate, manage, and control the smart devices. And of course, terminate and remove all access and connection to the improvements and accessory from any of seller's personal devices, including but not limited to phones and computers. This is really, really great to add this now that there are many homes that have these smart devices. And 11, special provisions. Insert only factual statement and business details applicable to the sale. TREC rules prohibit license holder from adding factual statements or business details for which a contract, addendum, lease, or other form has been promulgated by TREC for mandatory use. Okay, so the special provision only insert factual statement. 12, settlement and other expenses. So here's the following expenses must be paid at or prior to closing. You want to enter the amount not to exceed this amount here. All association fees, deposit reserves, and other charges resulting from the transfer of the property, not to exceed this amount here. And then you have prorations, paragraph 13, taxes from the current year, interest and maintenance fee, and definitely work with the title company and they will let you know what they would do the proration of the taxes, so that either the seller what you owe for the rest of the year, or and the seller what they owe for taxes. And then casualty loss. If any part of the unit which seller is solely obligated to maintain and repair under the terms of the declaration is damaged or destroyed by fire or other casualty, seller shall restore the same to its previous condition as soon as reasonable possible, but in any event by the closing date. So if there's anything happen, the seller need to restore the property to previous condition. And then there's default here. If buyer fails to comply with this contract, buyer will be in default and seller may enforce specific performance or seek such other relief as they may provide by law, or both releasing both parties from this contract. So that's default. And then there's mediation. It is a policy of the state of Texas to encourage resolution of disputes through alternative dispute resolution procedures such as mediation. And then we have paragraph 17, attorney fees. A buyer, seller, listing broker, other broker, or escrow agent who prevails in any legal proceeding related to this contract is entitled to recover reasonable attorney fees and all costs of such proceeding. Then we have escrow, paragraph 18. So you can see under escrow, the escrow agent is not a party to this contract and does not have a liability for the performance and non-performance of any party to this contract. Escrow agent may require any disbursement made in connection with this contract to be conditioned on escrow agent collection of good funds acceptable to escrow agent. Expenses and demand and damages and notices or under escrow. Then you have paragraph 19, representations. All covenants, representations, and warranties in this contract survive closing. And then you have federal tax requirements. So if seller is a foreign person as defined by the Internal Revenue Code and its regulations, or if seller fails to deliver an affidavit or a certificate of non-foreign status to buyer, that seller is not a foreign person, then buyer shall withhold from the sales proceeds an amount sufficient to comply with applicable tax law and deliver the same to the Internal Revenue Service together with approximate tax forms. Okay, that's relating to working with foreign person in the sales transaction. Then you have notices, paragraph 21. All notices from one party to the other must be in writing and are effective when mailed to, hand delivered at, or transmitted by fax or electronic transmission as follows. And buyer information go here, seller information go here. Paragraph 22, agreement of parties. So this contract contains the entire agreement of the parties and cannot be changed except by their written agreement. Addenda, which are part of this contract, are, and you want to check all that are applicable. Okay. And these are the 2 new addenda to this contract. So addendum regarding residential leases, addendum regarding fixture leases. And then paragraph 23 now is a consultant attorney before signing. And then there's, if the buyer, the seller have their attorney, the information will go here. And the reminder again, track rules prohibit real estate license holders from giving legal advice. So read this contract carefully. Then the execute date of the contract, broker fill in the date of final acceptance. That would go here, buyer and seller was signed. And then there's broker information, print names only, do not signed. And you can see team name is now in this section, the broker information section. Also here, team name. And then the changes here, disclosure pursuant to a previous separate agreement, such as a MLS offer or compensation or other agreement between brokers. Listing broker has agreed to pay other broker a fee. Disclosure is for informational purposes and does not change the previous agreement between brokers to pay a share commission. And you can see here option fee receipt, no longer seller, listing broker is now escrow agent in the blue, and everything else like their earnest money receipt, contract receipt, additional earnest money receipt needs to be filled out. Okay. There you have it. That is the promulgated by the Texas Real Estate Commission track residential condominium contract resale. I've gone over an overview, this residential condominium contract resale and the what's been crossed out and their update changes. And I highly recommend, if you have any questions, go to your broker or mentor to get those questions resolved for yourself. All right, thank you.